My name is Valerie Means, and I will act as chair for the meeting today. And I'll start by taking the role of commissioners. Commissioner Sugar.
Here.
Commissioner Seaven. Here. Commissioner Sullivan.
Here.
Commissioner Tuma.
I'm here.
I'm here. We have a quorum, and we have 4 items on the agenda today. I don't think a recess will be necessary this morning, but we may or may not recess depending on the progress of the items. And with that, good morning, Mr. Fournier. Would you please introduce the first item on the agenda?
Good morning, Chair Means and Commissioners. Item number 1 is docket numbers 21-133 and 22-221 involving the Minnesota Telecom Alliance, MTA, Minnesota Rural Electric Association, MREA, and LTD Broadband in the matter of a petition to initiate a proceeding to revoke the expanded eligible telecommunications carrier ETC designation of LTD Broadband LLC LTD and deny LTD's funding certification for 2023. The questions before the commission are: should the commission lift the January 18, 2023 stay of this proceeding issued by the administrative law judge? If so, how should the commission proceed? Since a briefing document was published, a letter requesting that the item be pulled from the agenda was filed by LTD. Responses to LTD's letter were filed by the petitioners, the department, and the Residential Utilities Division of the Office of the Attorney General. A further response was filed by LTD. The parties are available for questions. Thank you, Madam Chair.
Thank you, Mr. Fournier. If you're participating in this docket and you are online, would you please turn your cameras on so that commissioners know and can see who's available for questions. And if you're in the hearing room, would you please come forward? And all parties, please state your name and organization for the record if a question is posed to you. This matter and the filings here are of considerable size. Commissioners have reviewed the record in full, so I don't think it's necessary to hear oral arguments. We have a very comprehensive record from which to decide the motions before the commission today, and commissioners are fully informed of the positions of the parties and the support for the various arguments. So I just want to focus on just the issues that commissioners want clarification on. And so it's useful to go directly to questions. And I have a question for LTD before I turn to other commissioners. Is Mr. Howard here?
Yes, Madam Chair. Corey Howard for LTD Broadband.
Good morning. So I always frame my evaluation of motions with the commission's mission to make decisions in a manner that is consistent with the public interest and what is best for Minnesotans. And Minnesota is striving to provide broadband access throughout Minnesota, inclusive of unserved parts of the state of central relevance here. So funding is critical and hugely important, and it is in the public interest for Minnesotans to have that widespread access to broadband yesterday. So there are some issues in my view related to the timeliness of adjudication of these issues. Perhaps not urgent initially, but significant time has now passed, and we continue to have areas that are unserved and underserved. So my question is, and I realize filings were made earlier this week detailing some information on timing, but I'm wondering whether there is a date certain for action on the administrative appeal filed with the FCC. That information would be helpful to me for our purposes today. A few days have passed since that filing was made, so possibly there's been a notification of some sort. And I do understand how the FCC operates, so I'm not asking for comment on the particulars of the FCC process or why a date has or has not been calendared. My question just requires a yes or no, and if it's yes, then what is the date certain? And again, I'm not looking for a time frame. I'm looking for a date certain, yes or no, and if yes, then what is the date? Mr. Howard.
Madam Chair, Commissioners, no.
Okay, thank you. That is helpful to me. I don't have any other questions. Commissioner Tuma?
Thank you, Madam Chair. Mr. Johnson, I read all your briefings and late filings on the stay. I'm trying to get the stay and this suspension understood. If I were to follow your worldview with the stay and the suspension, I was struggling with the decision options in front of me. It seems like 2A is the same as 5, but maybe I'm missing something. So if you could just outline, if I were to agree with your worldview, what is the decision option I would go with? Don't give it to him, we'll always argue.
We're not gonna avoid that today, Commissioner Tuma. Chair Haynes, Commissioner Tuma.
State your name for the record.
My name is Dan Schultz here on behalf of the Minnesota Rural Electric Association and the Minnesota Telecom Alliance petitioners. The decision options, and I think your question was, are 2A and 5 essentially the same? I suppose so. I mean, it's just, you know, the stay is if you lift the stay, it goes back to the ALJ to complete the contested case proceedings on the revocation question. I think 2 and 2A do that. The
So
suspension
your
is,
recommendation to us would be, if I were to follow your worldview, what decision option?
we would recommend decision option 4 would probably be the one that I would recommend, that we would recommend, decision option 4. And that's the suspension. So decision option 4 would suspend the ETC designation. And we would also recommend decision option 2A, which essentially would lift the stay and then allow the ALJ to complete the contested case proceeding on the revocation. So in a sense, the suspension is analogous to a temporary injunction. Given the public interest implications and the evidence you now have before you, it makes sense. In fact, it's not only appropriate, but I think necessary to suspend the ETC designation while the contested case proceeding moves forward on its timeline to address the revocation.
I looked high and wide to kind of look for an example of suspension. What does that mean with an ETC, which it seems like by law I can revoke an application by Mr. Howler's company when he was in front of us, but we chose not to at that stage because essentially he did everything the same as everybody else did back then quite a while ago. He filed affidavits from his folks saying we can do. Your position now is, now we know more and we know what happened at the FCC, and so those affidavits that we relied on no longer have the same kind of, I guess, veracity maybe that they did back then. We also know more because you've also presented some evidence in front of us on their ability to perform by your evidence. Now, they have not had a chance to cross-examine those folks or anything, so I'm trying to understand what suspend means. And so if we suspend, what is sent back to the ALJ? Is the ALJ just simply going off of your revocation, or is it so binary, either revoke or don't revoke, that we don't have to send any other instructions back to them? Because it's basically our instructions back in our order in August were to deal with your motion to revoke. If we suspend now, do we have to ask the ALJ to deal with that issue also? I'm trying to understand suspend.
Good question, Chair Means, Commissioner Tuma. You don't have to do anything more to clarify for the ALJ. What the ALJ would have in front of him, if you were to lift the stay, is the very same matter you gave to him back when you issued your notice and order for hearing, and that is to consider whether the ETC designation LTD has should be revoked. What the suspension does is it changes the status quo in the interim while that proceeding is pending, analogous again to a temporary injunction. So your instructions to the ALJ don't change, but the status of the ETC designation changes because that designation will be suspended pending the outcome of that case. And at the end of that case, the ALJ would recommend revoking or not revoking, which would then come back to you for final decision on revocation. But meanwhile, the designation will be suspended, and as you've seen in our written materials, that's essential, we believe, to protect the public interest.
I'll get to that.
And you know all of that.
I just want to get to the procedural where I stand. So if I suspend, or we suspend, and take a stay off, send it back to the ALJ, and let's say Mr. Howard wins at FCC or at some federal district court, and does something with the FCC's actions so that no longer is he, his long form now is in place and he's okay, he's ready to go, okay? And the administrative law judge essentially decides not in your favor and says it shouldn't be revoked, he should get an LTD should get an ETC designation in Minnesota. And so the ALJ says that to me. What happens at that stage? What is sent back to us, and how do we deal with it procedurally?
What will be sent back to you in that scenario would be an ALJ recommended decision to not revoke. In other words, to leave the ETC designation.
Suspend.
Yeah, the suspended. It would essentially be to sort of not revoke. That will come back to you. At that point, you would decide whether you agree with the ALJ. If you agreed with the ALJ, you would, of course, lift the suspension, and the ETC designation would be in effect. At that point, the FCC would act accordingly. LTD would have an ETC designation. And if, under your hypothesis, the FCC has said that they've met the requirements for ETC, for the long form application is appropriate, then the public notice will issue from the FCC that will then sort of trigger the next step, which would be funding.
And that's essentially for us, that would be an automatic, we would be dealing with exceptions from the ALJ in front of us that are coming back to us in the normal course. And I saw in some of Mr. Johnson's filing something about LTD could, file something if something happened at the FCC for notice or whatever, and we could take it up. And so I guess that would be the scenario that the ALJ isn't finished with his work yet, okay? And the district court, federal district court, or FCC has changed their ruling. Is that something LTD then could file a motion with us directly to say, take the suspension off now, even though we're still doing the possible revocation? What happens in that environment? I'm trying to understand procedurally where that would sit. It seems to me like I want to hand it all over to the ALJ and bring it all back to us at once, but I don't know what suspend means and what you were saying in your briefings.
Chair Means, Commissioner Tuma, if the FCC were to reverse its staff on the long form question, that's your hypothetical. Your question then is, well, could LTD petition or file a motion with the ALJ to certify back to you the question of whether the suspension should be lifted? And they could certainly do that. I don't know.
In that scenario, then I am handing the suspension question to to the ALJ? And if that's the case, should I modify my August 16th order to say, I'm sending you the revocation and question suspension, and so that they understand clearly that we want them to deal with both?
Chair Means, Commissioner Tuma, you could do that. You could ask the ALJ, if you lift the stay, to not only continue and finish the proceeding on revocation, but you could ask the ALJ to entertain any motions and decide those motions on lifting the suspension if you grant the suspension. That's something you could do. However, parties are always free to ask the ALJ to certify a question back to you. I don't know whether the ALJ would do that or whether anyone would ask the ALJ to do that. But bottom line here is, if you suspend, as we believe you should, and lift the stay, which we also think you should, it would go back to the ALJ, and the proceeding you initially ordered would continue to conclusion on the question of revocation. What would happen during that proceeding with respect to your suspension, I don't know. Any number of things could happen. But the point is, and the central, I think, key to all of this is that public interest will be protected in the meantime.
Madam Chair, and Mr. Howard, you've heard the exchange. If I were to follow the position of the petitioners to suspend, let's just say we go there, I know you don't agree with that, okay? But let's say I go down that road, or we go down that road, would you prefer to have the question of suspension dealt with by the ALJ, or would that be something, if the rulings goes in your favor at the FCC, that you would want to come back to us essentially automatically and have us make a motion to lift the suspension? What would be your preference?
Mr. Howard.
Chairman, Commissioner Tuma, thinking through your question, I think the likelihood that the FCC is going to rule in our favor is effectively zero. I don't, when I read petitioners' letters about this, saying that imminently the FCC is going to reverse themselves, literally, I'm not assigning a 1% chance to that, I'm assigning a 0 to that, and our filings have reflected that. So I don't know that we really put a lot of thought into, I guess the ALJ at least gives us a chance to present evidence. I mean, the parties that are adverse to us here certainly have presented their own evidence. We haven't had opportunity to rebut experts or present our counter thesis. I think the appropriate venue would be in front of the ALJ. I just think that it's just wholly a waste of time and money and resources. The commission is busy, your ALJs are busy. This is as far from ripe as you can possibly think of. I think there is literally 0 chance the FCC is going to rule in our favor.
Well, that's helpful. Madam Chair, to our advocates for the public interest, for OAG and the department, I am convinced somewhat by reading the information given to me by the petitioners here, the co-ops and the Minnesota Telecom Alliance, that things have changed. We know more than what we knew back when we originally said we're going to approve this ETC designation. And had I known what I know now, I would probably sent it over. I think the posture right now is we're sending it over to the ALJ to make a determination whether this ETC designation should be given. And we'll let him work out who has the burden of proof here and there. That we'll decide. But in my mind, that it's always on the ETC person seeking ETC designation that they have their burden to show that. But had I known what I know now, that the FCC was going to say what they have said, and the information there, I probably would have fallen into that suspending it. But I look to you guys, it seems that you're saying the same thing, but I just want to confirm that you're okay with the extra process, because I think Mr. Howard and his company deserves a chance to cross-examine the witnesses and present evidence in the hearing. It seems logical at this point that if we know now what we knew then, you have been advocating strongly for us to send this to the ALJ to make a determination, carte blanche, on whether we should have an ETC designation. And that, as a result, the suspension kind of puts us in that same procedural posture. Is that your position coming from the public interest today, and why?
Mr. Dornfeld?
Chair Means, Commissioner Tuma, I think a couple things here. The department has supported a contested case and advocated for pursuing the contested case for the last 14 months. And we're more than happy to put on our case and prove that LTD is not yet to be an ETC in Minnesota. Frankly frustrated by the fact that LTD has delayed this proceeding in that way. More than happy to allow them to have their day to present evidence, cross-examine witnesses. The department is agnostic about which providers ultimately help Minnesota deliver broadband across the state. And if the department thought that LTD was capable of delivering that, our position in this case would be different. But we've retained our own expert in engineering that we asked to take an independent look at this and provide us their best estimate of what they thought LTD's capabilities to delivering on its commitments would be. And we have not received any evidence that suggests that they're capable of doing that, and we're happy to prove that in a contested case. I think the one thing that's different about a suspension versus a revocation is LTD has an ETC designation in this state. A suspension freezes the status quo and puts the burden on the moving parties, the petitioners, the interveners, the department, OAG, to go out and prove their case. I think that's the difference here versus sort of them filing an application in the first place, where they would have the burden, where LTD would have the burden. I don't know if that's helpful, but I think that's kind of where the department's perspective on this.
And you're representing the state, so the state interest here is I think, as when I read the record, is the potential for a blocking out of another carrier coming in and providing that service in that territory, who could actually get concerned has always been that blocking could
in great doubt, and we think it is vital that the commission change the current status quo and suspend so that more reliable providers can enter this space.
I'm assuming the OAG, I want to make sure 2A and 4, as indicated by the moving parties.
Commissioner Means and Commissioner Tuma, yes.
And then Mr. Northfield, number 6, I'm trying to get my head around that. Is that really necessary? I mean, I don't mind asking customers what they're thinking, but it seems like there is evidence on the record already, and we need to go through the extra step of doing this notification.
Chair Means, Commissioner Tuma, in the department's view, it's a useful exercise. It's something we customarily do in a contested case. For example, for like a rate case, where we'd ask consumers for their input. Here, where the question is really about LTD's fitness to be an ETC in the state, hearing from and inviting the input of existing LTD customers, I think is useful, and that's the reason why the department made this recommendation. Certainly, there is that record or comments in the record from retail customers about LTD's performance already available. I certainly think it would be useful to hear from more customers, but does this make or break the proceeding? No, I don't think so.
And finally, Madam Chair, Mr. Howard, would you be opposed to number 6?
Mr. Howard?
Yes. I'm sorry, Chair Means, Commissioner Tuma, yes, we would be opposed to that. We think that the parties have not made the case that the commission is powerless to act in the unlikely event that the FCC does ultimately approve our long form. We think it's a waste of resources for 6. It's clear that the MREA and MTA dislike us as a competitor. I think that's true, and I think the OAG mentioned that a county dislikes us. I think that county the sewer county dislikes us because they had a preferred vendor that is not us, that they wanted to receive grant funding. I think that's, when we're talking about counties, that's certainly the case for that county.
Those are all the questions I have, Madam Chair.
Commissioner Stevens.
Thank you, Chair. Thank you, Chair Means. Mr. Howard, I was listening carefully when you were answering Commissioner Tuma's line of questions, and I just want to, I think I know the answer, but do you still want ETC status in Minnesota?
Chair and Commissioner, we do. I mean, I think that it's, I think the agenda here of the petitioners is to sort of influence the FCC to do.
I didn't ask about that, Mr. Howard. I was asking, it sounded like you didn't want to go through, I mean, I was thinking coming into this similar to how Commissioner Tuma just outlined the line of questions, but I heard you say that if the matter is sent back to the ALJ, that's a lot of effort for your company to engage in a contested case hearing. And one of the questions, I think that if I'm following what Commissioner Tuma is thinking, the direction he's headed is that the ALJ will advise us, ultimately the commission, on whether we should revoke your ETC status. And if you're ready to just give up your ETC status now, we could save a lot of that contested case work.
I understand the question. I guess the parties have gone through great efforts to besmirch LTD's capability. We're deploying tens of thousands of fiber to the home locations. I mean, experts hired by the department and the petitioners obviously represent rural ILECs who are our competitors, and that's who pays them. The experts are funded by projects from these companies. So we would, if this does get to an ALJ proceeding, certainly we're going to put on a case and rebut the allegations from these experts. We just think it's a waste of judicial resources, but certainly we're not going to just raise the white flag and say, oh, these guys are right. That's not going to happen. We'll if this gets sent back to an ALJ, we'll have a contested case hearing and show the evidence that we're fully capable of performing the RDOF obligation, which, as I outlined earlier, is very unlikely to happen, at least under the current FCC administration.
Okay, thank you.
Do other commissioners have any further questions? No? If there are no further questions, let's move on to deliberations. Does anyone have a motion?
Well, Madam Chair, up to me, I would move, as indicated by the petitioners, 2A and 4. I would just do that only. I don't see 6 benefits at this stage. Certainly, comments have been coming in. People have been getting comments. I don't know if requiring LTD to do more at this stage would be all that beneficial. So, and my reasoning behind it, Madam Chair, was, and it goes to when we made the original decision on the ETC designation, they are based on affidavits from the applicants, and those we assume to be true. And I think there is sufficient evidence on the record by reliable information that maybe that wasn't as accurate as possible, and that should be at least tested in an ALJ proceeding, in a contested case proceeding. It's my understanding if we send this back as required by 2A and 4, that the ALJ will understand that this is a binary decision about whether it should be or shouldn't be an ETC designation, and we'll have an opportunity to address those issues when it comes back to us on exceptions from the parties at that stage. So I think the ALJ will be able to sort it out with that. I was just worried whether we needed to make some statement modifying their August 16th order, but I'm convinced that we don't necessarily need to do that at this stage. So that's my rationale behind it. something happens in between time that we don't know about, it doesn't have to come back to us in a rush, it'll come back to us in the normal course of the ALJ proceedings.
So Commissioner Tuma, you're moving to B and 4.
To A or to B? I heard
2A.
I heard 2A. Thank you.
But that also includes,
Sorry, I didn't hear that response. I heard 2A also originally. Is it 2A or B?
2A.
and 2.
2,
Yes.
2A, and 4.
Thank you.
I think, Commissioner Tuma, if I may, Madam Chair,
Yes, please.
I support your motion. I think that the question before that ALJ should also include, what has happened with LTD in other states, that other states have rejected their ETC status, and I assume that the parties will bring that up and use that, to help the commission ultimately decide whether we need to come to a different conclusion, but I'm supportive of your motion. Thanks for stepping into it.
Any further discussion on the motion? On Commissioner Tuma's motion, Commissioner Sugar,
Yes.
Commissioner Seaven,
Yes.
Commissioner Sullivan,
Yes.
Commissioner Tuma.
Yes.
I also vote yes. We have 5 yes and 0 no's. The motion prevails. Thanks, everyone.